Welcome to the Deep Dive. This is where we take complex subjects, break them down, and give you the core insights you need. Think of it as your shortcut to getting up to speed.
Exactly. And this particular deep dive is part of our ongoing series tackling the Manual of Patent Examining Procedure, the MPEP.
Right, the MPE, that huge essential guide for patent examiners. We're going through it section by section.
Thousands of pages, really. Our mission is to make it digestible. Explain the key stuff and why it matters to you.
Today, we're jumping into Chapter 1800. This whole chapter deals with the Patent Cooperation Treaty, the PCT system.
Yeah, the PCT. It's absolutely fundamental for anyone looking at international patent protection.
And within Chapter 1800, our focus is laser sharp today. MPE, Section 1870.
Section 1870, titled Priority Document and Translation Thereof. This one's all about the paperwork. Well, the crucial paperwork you need when claiming priority to an earlier patent application in your international PCT filing.
Claiming priority, like linking back to maybe a U.S. provisional or a foreign application you filed first?
Precisely. You're telling the system, hey, look back at this earlier date for what I disclosed then. Section 1870 details how to handle copies and translations of that earlier document.
Okay, so our mission here is to really get under the hood of these requirements. What do you need for priority docs and translations, especially during that international preliminary examination phase?
Exactly. That phase is governed largely by PCT Rule 66.7, and Section 1870 unpacks how that works. We need to figure out what happens practically if those documents aren't ready when an examiner needs them.
Because messing this up sounds like it could be problematic.
Oh, it can have serious consequences.
Oh.
Let's unpack it. When you file that PCT application and claim priority, you're essentially asking for the benefit of that earlier filing date for everything covered in that first application.
And that date is gold, right? It establishes your place in line.
It's incredibly valuable. It's your stake in the ground. It can potentially neutralize prior art, inventions, publications, even sales that popped up after your initial filing but before your PCT filing.
That intervening prior art, that stuff that would sink your application if you only had the later PCT date.
That's often the biggest hurdle, yes. So because that earlier date is so vital, the system needs a way to check what you actually disclosed back then. The International Preliminary Examining Authority, or IPEA, needs to verify it.
To make sure your current claims are actually supported by what you filed way back when.
Correct. And that's why they might need to see the priority document itself. MPP Section 1870, drawing on PCT Rule 66.7, tells us how the IPEA gets that document during their examination.
Okay, let's start simple. What about just needing a copy of the priority document? What does Rule 66.7, specifically Part A, say?
Right, Rule 66.7a, it deals with the need for a physical or digital copy of that earlier application you're claiming priority from. During the IPEA examination, the examiner might decide they need that copy.
Why would they need it?
Well, they might need to check if the disclosure in that priority document genuinely supports the claims you're making now in the international application. This is key, especially if there's potential intervening prior art they need to assess.
Okay, makes sense. So if they need it, how do they get hold of it? Do they just ping the applicant straight away?
Not usually. If you, the applicant, did your part initially under PCT Rule 17.1.
Ah, Rule 17.1. What's that cover?
That's the rule about submitting the priority document in the first place. You either provide it when you file the PCT, or you request the receiving office, like the USPTO, perhaps to grab it and send it on your behalf.
Okay, so if I handled that correctly, it's fine.
Then the IPEA will usually try to get the copy from the International Bureau, the IB. They act as sort of a central library or repository. They'll just request it from the IB.
Got it. They try the central source first. But what if something went wrong earlier? Like I messed up the Rule 17.1 step. Or maybe the document just isn't easily available to this specific IPA.
Okay, this is where the teeth come in. If you, the applicant, fail to comply with Rule 17.1, you didn't submit it, didn't request transmission properly, and, critically, if that earlier application isn't already sitting with the IPEA or easily accessible via an approved digital library,
So what happens?
then the IPEA examiner has an option under Rule 66.7a. They may issue the International Preliminary Examination Report, the IPR, as if no priority claim had been made for that specific earlier application.
Wow, hold on. So if I messed up way back at the start with getting the priority doc into the system and the examiner can't easily find it later, they might just pretend I never claimed priority.
For the purpose of their report, yes, it's a significant step.
What does that mean practically in the report?
It means the examiner writing that report will analyze your claims based only on your PCT filing date. any prior art that emerged between your priority date and your PCT date.
Uh-oh.
Yeah, the examiner might suddenly see that art as fully relevant because, in their analysis for this report, your claim to the earlier date is being disregarded.
So it doesn't kill the priority claim permanently, maybe, but this key report won't reflect it.
Exactly. The report, which heavily influences what happens next in national offices, won't give you the shield of your earlier date against that intervening art. It flags a potential major problem.
Okay, that really does have teeth. So that's the copy. What about language? What if the document is available, but say it's in Japanese, and the IPEA examiner only reads English?
Good question. That brings us to Rule 66.7b. This part tackles the language barrier.
How does it work?
If the priority document is in a language that the specific IPEA handling your case doesn't accept, and if the validity of your priority claim is actually relevant to their examination, which it often is, for checking prior art, then the IPEA may send you an invitation.
An invitation for, or translation, I assume.
Precisely. An invitation to submit a translation of that priority document into a language they do accept, like English in your example.
Is there a deadline attached to that invitation?
Yes, a strict one. You get 2 months.
2 months from when?
2 months from the date the IPEA sends the invitation. Not when you receive it, but when they send it.
Okay, 2 months. And if I miss that deadline? If I don't get the translation in on time?
But the consequence is pretty much the same as failing to provide the copy when asked. The examiner may again proceed as though the priority had not been claimed when they write up that international preliminary examination report.
Okay, so failure on the copy or failure on the translation when requested. Both can lead to the examiner effectively ignoring the priority claim in their report during this phase.
That's the crux of it for Rule 66.7. It boils down to giving the examiner what they need to verify your claim. If they can't get the document or they can't read it, they can't confirm its relevance, especially against that tricky intervening art.
So the message seems pretty clear. You need to make sure the IPA can get and understand your priority document if they need it during this preliminary look.
Absolutely. Let's use that Japanese application example from the source material to make it really concrete.
Okay, so imagine I file my international PCT application, and I'm claiming priority back to an earlier application I filed in Japan.
Right, and let's say your PCT application ends up being examined by an IPEA that works mainly in English, perhaps the European Patent Office or the USPTO acting as IPEA.
Okay.
Now, they need to understand what's in that Japanese document to see if it properly supports your current PCT claims, especially if they've found some potentially relevant prior art dated, say, between your Japanese filing and your PCT filing.
But the document's in Japanese and they work in English.
Exactly. So if this English-speaking IPA can't easily get hold of that Japanese priority document or an English translation through the usual channels like the IB or a digital library they use,
Then, based on Rule 66.7b, they're likely going to send me that invitation for a translation.
very likely. You, the applicant, would probably get an official notice asking for an English translation of the Japanese application. And depending on how Rule 17.1 was handled initially, they might also need a copy of the original Japanese document itself if it wasn't already properly supplied.
So I might be on the hook for providing both a copy and an English translation?
It's possible, yeah.
And I'd have that 2-month window to get it to them.
Correct.
And if I fail, if I don't provide the copy or the translation they asked for within those 2 months?
Then, failure to comply could jeopardize the recognition of your priority claim specifically within that international preliminary examination report.
Okay, let's hammer this home. Why is that specific outcome, having the priority claim disregarded in the report, such a potential disaster for me, the applicant?
Because of that intervening prior art. Let's use dates. Say your Japanese application was filed January 1st, 2023. Your PCT was filed January 1st, 2024. Now imagine someone published a really relevant paper or launched a similar product in June 2023.
Okay, right between my 2 filing dates.
Exactly. If your priority claim back to January 2023 is recognized and validated, that June 2023 publication is after your effective filing date.
So it's likely not prior art against my claims. Phew.
Right. Your priority claim acts as a shield. But if because you didn't provide the translation when the IPEA asked, the examiner drafts their report as if you hadn't claimed a priority.
Then my effective date for that report becomes January 2024.
Correct. And now that June 2023 publication is before your effective date.
Meaning the examiner can cite it against my claims in their report.
They certainly can, and likely would if it's relevant. This could lead to an unfavorable opinion on patentability in the IPEA. It doesn't mean your patent is dead instantly worldwide, but it creates a significant hurdle and a negative signal heading into the national stage.
Wow. So a procedural slip-up, like missing a translation deadline, can directly impact the substantive assessment of patentability against prior art. It literally changes which references count against you.
It absolutely can. It's not just ticking boxes. It's about defending that crucial earlier filing date. That's why these rules exist, to ensure examiners have what they need to do that validity check properly.
Okay, so these rules under PCT Rule 66.7 are specifically about that international preliminary examination step. Does this whole issue of needing priority documents or translations pop up again later? Say, when my application enters the U.S. national stage?
Oh, yes. It definitely can resurface. Once your PCT application moves into the U.S. national stage, a U.S. examiner takes over.
Yeah.
The rules governing priority in the U.S. are based on U.S. law, like 75 U.S.C., Section 119 and 120.
But they might still need the document.
Yes, the U.S. examiner might also require a copy, or very commonly, a translation of your foreign priority document.
For similar reasons. To check against prior art.
Very similar reasons, and arguably even more critical because the U.S. examiner is making the final call on patentability for the U.S. patent. It's especially crucial if they find potential intervening references.
That art falling between the priority date and the PCT date again?
Exactly. If a U.S. examiner finds art from that period, they must be able to confirm that the invention you're claiming now in the U.S. application was fully described and enabled in that earlier priority document. That's the only way you get the benefit of the earlier date to overcome that reference.
So the U.S. examiner needs to read the priority document, possibly via translation, to make sure what I'm claiming today was really invented and disclosed back then.
Precisely. They need to perform that comparison. If the U.S. examiner can't read the priority document because there's no translation, or if they don't have a certified copy if needed, they might not be able to conclude that your claims are entitled to the earlier date.
And if they can't conclude that,
then the intervening prior art reference stands, and it could block your U.S. patent for those claims.
man, it really underscores how these documents are literally the key evidence for that priority claim.
They are the foundation. Without them, or without them being accessible and understandable, the claim might not hold up under scrutiny.
Okay, let's bring this home for the listener. Connecting all this back to you listening. What's the big takeaway from MPP Section 1870 and this discussion about Rule 66.7?
I think the most crucial point is this. Managing your priority documents and any necessary translations correctly is absolutely fundamental. It's not optional if you want that earlier filing date recognized throughout the whole process.
These aren't just minor administrative tasks you can put off.
Not at all. They are core requirements for validating your priority claim. As we've seen, that validation can literally be the difference between getting a patent or not, especially when intervening prior art exists.
So overlooking these steps, like messing up the initial submission under Rule 17.1 or failing to provide a copy or translation when the IPEA or a national examiner asks, can have really severe consequences. It could effectively strip away the protection of your early filing date.
It demands diligence. You need to know the rules, track deadlines, and understand what each office might require, both internationally and nationally. Being proactive is way less stressful than scrambling when your priority claim is suddenly questioned.
It's just fascinating how these seemingly procedural details in the MPP link directly to the ultimate strategic goal, securing your patent rights.
The procedure and the substance are often deeply intertwined in patent law.
Absolutely. Now, before we wrap up, we really want to give a special thank you to Mike Shepard. He's the creative director who organized this entire MPEP audio series.
Yes. Thanks, Mike. And also the necessary disclaimer. This summary of the MPEP was put together using AI tools like ChatGPT and NotebookLM. It might have errors or leave things out. It's for general educational and informational purposes only.
Right. It's definitely not legal advice or a substitute for formal training. For the official word, always consult the actual MPEP, talk to a qualified instructor, or best yet, speak with a registered patent practitioner.
Please do.
Okay, so to leave you with a final thought to chew on, building on everything we've discussed. Knowing how detailed and strict these procedures are for priority documents and translations under PCT, how might your strategic choices way back at the beginning, like deciding where to file your very first application, or in what language, how might those early decisions actually set you up for a smoother ride internationally and better protect that all-important priority date later on?
Yeah. Thinking ahead about the downstream requirements could definitely influence those initial filing strategies. Something to consider.
Definitely something to mull over. Thanks for joining us for this deep dive into MP Section 1870. We'll continue our journey through the MPEP next time.